All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here for oral argument in 1 CACV 190405 Alosi versus Citibank. These proceedings are being video recorded, so we'd ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Mr. Abney, you're responsible for watching the clock to reserve any time for rebuttal if you so desire. You may proceed.
May it please the court, my name is David Abney. I'm representing the appellants in this matter. I hope my voice holds out. I'm not used to talking so much in one day. The note and the deed of trust came supposedly to Citibank in a very strange way. The note was created on January 10, 2007, and then sometime on or before April 1st, 2007, it was supposedly endorsed by Washington Mutual by an officer there, Vice President Cynthia Riley, who wasn't there. She wasn't working for Washington Mutual at the time. She had been laid off in November 2006 and didn't get her job back until January 2009. But somehow this endorsement of hers appears on the note. Then the note supposedly is transferred to Citibank. So Citibank is supposedly holding on to the note. Then on...
You agree someone was entitled to receive a payment on the mortgage?
I think so. Don't know who, though.
But so why isn't that a matter between the bank, presumably the one that your client's contracted to pay the mortgage, and if they've assigned it to someone else, well, why does that change whether they're entitled to not pay the mortgage?
You have to be paying it to the proper person, and the Citibank is not the proper person.
His defense was not, I didn't know who to pay this, correct?
Correct. It's just saying not to Citibank, so Citibank doesn't have the right to enforce, the deed of trust, anything. Citibank doesn't have that right.
Don't you need to at least put the payment in for someone and say, I'm not sure who to make this payment to. I'm going to pay it into the court and let the other parties decide.
I think that's pretty much the system that's been set up and that he's been honoring. Payments have been going in.
But that's after the fact. Why?
Right.
He's not disputing that he was behind on the mortgage payments and has didn't make up all of the delinquent payments, did he?
I think he would dispute that. I don't know if that's something that could be properly disputed or necessarily should be disputed. But there again, what matters is where is this money supposed to go, and it's not supposed to go to Citibank. Citibank doesn't have any enforceable rights as far as we can tell.
Well, that's a dispute between the banks, correct? Not between him. I mean.
Well, yeah, they're after him to make the payment to Citibank's after him to make the payment to it, and if Citibank's not entitled to do that, then Citibank doesn't have a right to be in court saying you have to pay us.
Now, the only issue before us is the post-judgment order, correct? Whether or not it was properly denied. Because there was a judgment, it was entered.
Ah, yes. Well,
and then you didn't appeal.
Well, I had nothing to do with that.
I know. That was the regal you.
Yes, yes.
Your client didn't appeal. And
right.
Then there was a post-judgment motion that was filed.
Right, there was a Rule 60 motion. And in fact, that's one thing I want to apologize for the court. I came up with this great theory about how the second judgment supersedes the first judgment and all that. I did a lot of research on it. I think I drank too much Diet Coke that night. And I worked hard on that theory. And then I went back and looked at it again. And really, this is a simple Rule 60 problem. There was a long-winded title to this motion that Mr. Alosi filed while he was representing himself. I forget the first part of them. Plaintiff's emergency motion to cancel the sale scheduled for February 19, 2009, and motion to vacate or set aside the order dated October 23, 2018.
Somehow, there's no appeal from that, though, right?
No, but he did file it. That was a Rule 60 motion. And then the court finally resolved that Rule 63 motion in what it called the final judgment.
When was that? It's before these proceedings, right? And we're not talking about an appeal from that ruling.
Well, yeah, that's
That's this.
then the
this
notice
one,
of
this
appeal
one
was
is-
filed after the final
This is-
judgment, which is
okay.
Index of Record 71. So you had this.
But our focus is based on whether or not the trial court properly or correctly denied the post-judgment motion. That was my original question. That's the issue that we have before us. Correct?
No, because the Rule 60 motion preserved and stayed the notice of appeal time based on the original judgment. So
I thought it already run.
No, it was within the 6-month period. You can do a 6-month, you have a 6-month window if you're filing a motion based on mistake, fraud, misrepresentation, and that's what Mr. Alosi was arguing, that he was the victim of fraud
Okay,
and,
well,
and mistake.
chicken or egg. If the trial court said, nope, no fraud, then you're untimely and it doesn't stay anything, and then so we're looking, or we can just, step one is to determine whether or not there was a reason to extend the period, correct?
Right. But the Rule 60, my understanding is if you file a Rule 60 motion, you've got a good faith basis for filing it, and there's grounds such as fraud, misrepresentation, mistake, then that automatically tolls the notice of appeal time. And finally, that was denied. The final judgment denied.
Let's go back to tolling the appeal time.
Okay.
What case supports your theory of the extension? What best supports that proposition that you get 6 months even if your Rule 60 is denied to appeal? Or should you file them simultaneously?
The plain language of Rule 60C1, I believe. And it's, if you have the judgment, it's got 54C language, you file a motion to set aside from Rule 60, then you get the addition, for those grounds, you get addition, it's stayed, the notice of appeal
I
time is stayed.
understand Rule 60 gives you 6 months to file your Rule 60 motion.
For certain grounds.
For certain
For some
grounds.
others, it's 15 days for whatever reason. I don't know who set that up, but for some, it's 15 days, and then for these other specific ones, such as fraud, mistake, misrepresentation, you get the 6-month period. And they filed it within the 6-month window. Then you get to the trial court disposes of that in what it calls a final judgment and refers to Rule 60C in the title of that document that it filed. And then the notice of appeal is filed within a month after that, filed timely after that. That's when I came into the picture, I think, right about there.
So that goes back to, again, my question is, our focus is based on the notice of appeal from the most recent judgment which denied your Rule 60C motion, correct?
Yes, with the proviso that the notice of appeal time was extended by the Rule 60 motion, which would relate back to the original judgment as well. I hope that works. I think under the plain language of Rule 60C, it does work. But at the very least, there's an appeal here, validly, even if it's only on the limited grounds of an appeal from the final judgment, the latest judgment. And I did a lot of research on the final judgment theory, and you can take that with a grain of salt or as you will. I think it holds up. The problem is the note and the deed of trust somehow got broken apart. The Citibank says it was transferred to it after April 1st, 2007, based on this forged endorsement. It was transferred to it, and then WAMU.
Could the court conclude that the endorsement was authorized? Somebody authorized them to use a stamp?
Yes, oddly enough, the court said something like Citibank. It was a Citibank authorized endorsement, and it wasn't a Citibank employee who did it. It was supposedly a Washington Mutual employee who actually wasn't working for Washington Mutual at the time.
There wasn't conflicting evidence about whether she still was working?
Yeah, there was a transcript. There was no proper objection to the transcript at all. It was a deposition in another proceeding, was brought in and used against Citibank, and she said, I was not working there at the time from this huge window of time, and the endorsement happened in the middle of this.
There wasn't any conflicting evidence on that issue?
None that I'm aware of, Your Honor. So then you've got Washington Mutual, they call it WAMU, great name, but anyway, it goes into receivership. And then FDIC assigns the deed of trust to Chase. So the note and the deed of trust have been broken apart for whatever reason. You would think that the note and deed of trust would have been assigned at the same time over to Citibank. It claimed it got the note right away, somewhere around just after April 1st, 2007. And then on April 21, 2009, Chase assigns the deed of trust to Citibank. So Citibank has both things together. That would lead, I would submit to the court, a reasonable financial institution to do an investigation as to what happened, why the note and deed of trust were broken apart, and whether this is indeed a proper endorsement or a forged endorsement. That would eliminate the holder in due course. You know, that sort of notice that there's a problem, that there's a need to investigate to what's going on, and Citibank didn't do it, as far as we can tell. When a signature under our statutes, a forged endorsement is ineffective. That's ARS 47-3404, subpart A.
I'm sorry to keep interrupting, but the depositional testimony that was provided for Ms. Riley, that came from a California case, correct?
Correct.
And in that California case, the bank also provided additional records, correct? And they did it in this case as well.
Correct.
And the bank records that were provided, didn't they show that Ms. Riley worked for WAMU between 2004 and 2008, and then she was with Chase from 2008 until mid-2013?
There was some evidence to that effect, but it conflicted with her deposition testimony, which was right on point and very clear. I didn't work for Washington Mutual over the period of time.
And just so we're clear, the California court didn't buy her depositional testimony and actually relied on the bank records.
It may have, Your Honor, yes.
And so our trial court here, the Superior Court, resolved it in the same fashion.
Yeah, and it's a question of fact, though. You can't be doing that on the summary judgment.
Well, that's why we go back to this was on a Rule 60 motion, right?
Well, yeah, Rule 60 motion that spins back to the original summary judgment. And the Rule 60, it should have been set aside because there was mistake. The rule's very clear. It says mistake, and there was a mistake, plus fraud and misrepresentation on the part of Citibank. It's coming into the court and saying, well, look, we've got this great endorsement here, and the judge went sort of sideways on that and said, well, a Citibank employee endorsed the note, and that's not what happened at all. It wasn't a Citibank employee under any view of the evidence that I'm aware of. She was not an employee of WAMU. She wasn't there. And she herself testified, well, I didn't authorize this stamp business. I didn't sign, didn't authorize signature, didn't do any of those things. So you've got a situation where at the very minimum they've got to investigate. If you've got to investigate, then you can't be a holder in due course. Plus, you get the fact that if it's a forged endorsement, you can't be a holder in due course. I think I'll sit down while I'm moderately, at least somewhat, even.
All right.
I reserve my time.
You may. Counsel?
Good morning. Pardon me. May it please the court. My name is Joel Newell. I represent the appellees, Citibank National Association as trustee and trust for the register holders of WAMU asset-backed certificates, WAMU Series 2007-HE2 Trust, and the Servicer Select Portfolio Servicing. Your Honor, the court has raised a couple of questions I'd like to address first in relation to the separation of the note and the deed of trust. The note endorsed in blank or a bearer instrument was transferred from WAMU to Citibank in April of 2007 pursuant to a pooling and servicing agreement. And under the Arizona revised statutes, that there does not have to be a simultaneous assignment of deed of trust for that security or that lien to be with the person who's holding possession of that note. What is common in the industry of real estate is that generally an assignment of mortgage will be recorded shortly before a notice of trustee sale is being recorded, which will identify the notice of the beneficiary of that obligation. So in this case, there is a time difference between when the note was transferred in 2007 and when the assignment of deed of trust was executed and recorded. The execution of that assignment of deed of trust was by J.P. Morgan Trust as successor to WAMU. Washington Mutual. The reason for that is as the FDIC took over Washington Mutual and JP Morgan acquired the majority, if not all, the assets of Washington Mutual. So the person who would be then the party to execute that assignment at a later date would be JP Morgan in its capacity as successor to Washington Mutual. So it's not uncommon for the two to be separated. Sometimes they're simultaneously done with the transfer and assignment, the recording of the assignment of deed of trust, but the distance or the time between the two does not invalidate the transfer of the note from Washington Mutual to Citibank in 2007. In regards to some of the reference to the deposition transcript of Ms. Cynthia Riley as Vice President of Washington Mutual, the deposition transcript, I believe, was from a Florida case, and it's been used before in other cases. As the court noted, Judge William Alsup in the Northern District of California was the one who went through the deposition transcript and kind of pointed out how the deposition transcript itself contradicts the theories posed by the appellants in that Ms. Riley was laid off in 2006. She was no longer with a certain department of Washington Mutual, but she was still employed as vice president through 2008. And that's in relation to, as the court noted, the declaration of J.P. Morgan Chase that went through her her employment history during the time she was with Washington Mutual up through the time she's with Chase. And that was relied upon by Judge William Alsup in the California case in parsing out and distinguishing the similar type of issues raised in this case that was raised in that case. It was the ultimate beneficiary or transferee of the note may have been different in the District of California case compared to here, but it was still dealing with a 2007 note. It was still dealing with Ms. Riley's deposition, and it was still dealing or questioning the endorsement or bearer notation of that note and whether or not the beneficiary and the person could proceed with enforcing their lien rights. So what I believe is that the trial court took those into consideration, rightfully so, in the now crux of what the appellant were saying at the trial court level, saying, wait, we found this new evidence. The lender here, the appellees, are not being forthright or in the sense of the mistake or fraud of Ms. Riley's employment history, and they contradict that. And I believe the trial court correctly took that into consideration when denying the Rule 60 relief. With regard to...
But was that an issue that could be resolved without making a factual determination at a trial? Is that what I'm understanding Mr. Abney's argument to be?
Yes, if I understand Mr. Abney's argument as well, and yes, I believe it could be done at the trial court level. The reason being is that the declaration of J.P. Morgan, the person whom which Ms. Riley was working for at the tail end of her tenure, provided the declaration in support of that issue. And so it's not an issue as there's no factual dispute then at that point. It's more as to it affirms Ms. Riley was a vice president through 2008 as the stamp indicates.
So her previous affidavit doesn't suggest that she wasn't working in any capacity for WAMU?
I'm sorry, whose affidavit?
Her deposition.
Her deposition.
Okay.
Testimony.
Her testimony.
Correct. So in the deposition transcript, she does testify that in November of 2006, she was laid off. But later it was clarified in what was, at that time, she was essentially in a dual role. She had the title of vice president, and she was managing what's called the secondary delivery operations. And so with that, in November 2006, she was laid off from her role in the secondary delivery operations, but maintained the title of vice president, and I believe had a more broad responsibility. I believe even in the transcript, it provides that she was...
Seems like an odd thing to say I've been laid off if you're still
Working.
I understand, and I think that's the reason why the deposition transcript has been used, not only in this case, but other cases, because it gives the impression of she's no longer working there, but she was still working there. And in relation to that, the court will bear with me a moment. I think I'd find the actual... So, yes, correct. In the deposition transcript on page 37, there was a question asked that said, when did you cease being a vice president with the bank? And the answer was 2008. She then clarified that was January of 2008, which then contradicts the, not necessarily contradicts, but further elaborates on the response of being quote unquote laid off in 2006. So from the position of the appellee, we have an obligation to which the appellants do not deny incurring back in January 2007, that Washington Mutual was the original lender, that the note deed of trust provide that can be transferred to another party at some point during the course of it being serviced. It was transferred in 2007, in that the Citibank is the correct beneficiary of that deed of trust. Select Portfolio Servicing is the servicer and attorney in fact. So they are the one who has possession of the note for the benefit of Citibank. And so with that, the rights that Citibank has to enforce its lien on the real property in the event of not being paid are statutory provided, and generally Arizona revised statutes allow for a quick resolution in the form of a non-judicial foreclosure sale. Unfortunately, this one's taken a little bit longer to process. But with that being said, that the appellees are the correct parties who are enabled to enforce the note and deed of trust. The court, I think, posed a question in regards to the borrower remitting payments. To my knowledge, and throughout this proceeding in lower court leading up to today, it hasn't been a question of, I'm getting a mortgage statement from Washington Mutual and Citibank, and there wasn't a confusion as to who to pay. It was just, unfortunately, the mortgage wasn't being paid, and so the appellees proceeded with enforcing the rights under the deed and trust. With that, if the court does have any additional questions, I'll rest on the information provided in the papers.
All right, thank you, counsel.
Thank you.
Mr. Hamby, let's just clear this up because I don't think I was clear with you. Okay, so October 2018, you get the result that you don't like, and you think that's still teed up based on the Rule 60 motion extending your time for an appeal. But when you look at the Civil Rules of Appellate Procedure 9, if you move for relief, you have to do it 15 days after the judgment to stay the time for appeal. Did your client do that 15 days after?
No, Your Honor.
So where are we getting this extension?
We're getting that from Rule 60C, and we are hoping that that works, because you're allowed the 6-month period to do that for certain
But then
times.
you get to appeal if you don't get it.
Right.
But from the 60C to see if we believe the trial court was wrong in denying your Rule 60C relief.
Well, I don't know if this is chicken and egg or 6 and a half dozen, but
Okay.
the end result is there is a viable appeal at the court from at least the
Well, that's why we're here. We're here to talk about whether or not the trial court
okay.
properly granted that.
And the final judgment was April 24, 2019.
But you agree there's some clarifying evidence that clarifies what the employee who said she was laid off, but clarifies that she's...
Well, she said, and it's on page 15 of the opening brief, but she testified she was laid off November 2006, didn't get her job back until January 2009. That's page 64, line 14 to page 65.
But then there's a
line
clarification from the bank, and she doesn't follow up. You didn't present a new affidavit saying, well, no, the bank made a mistake when it said...
I don't think so.
Was there in a different capacity?
But you've got a conflict right there. She says one thing in her deposition, and the bank says, well, hold on, we have a different kind of evidence. Somebody's got to decide that, and it shouldn't be a judge. It should be the trier of fact that actually decides that. So,
but if the bank's clarified it and said, yes, she was laid off from that position, but she was still employed, these are records that show she was still employed. If she doesn't come back and dispute that.
well, she says I was flat laid. She
said that earlier, though, and then after the clarification, there's nothing new that you're just relying on something from this older case.
Right. It's not the strongest evidence in the world, but it is evidence, and there is a conflict. Plus, she also specifically testified that she never endorsed any notes and never even put an endorsement stamp on the notes, never authorized that. So, you've got
notes in that case, not not this case.
ever. She says she didn't do it in her deposition. So you've got this weird endorsement that somebody came up with and put on there. And as I say, at a minimum, you've got this strange.
But don't you need to have had some indication from her in this case that she didn't do it? You're just talking about something that happened in a Florida case.
Right. Well,
So
she was working in Florida. That's why the Florida case came up. That's why she was deposed.
But why is that enough in this case when there's been clarifying information from the bank?
It's not enough because you may call it clarifying information. I call it conflicting evidence, which I think is what it is. You got one story here, you got another story here, and somebody's got to say, well, one's right, one's wrong, or somehow meld them together. Far beyond my capacity, and you really need a room full of people talking about it. The jury, it's a jury problem.
Or you get a jury trial on a Rule 60C motion.
Well, when it comes back down, you get a jury trial because the Rule 60C motion would result in setting aside the judgment, and back you'd go. You asked an earlier question that really got me thinking for a change, and the question was sort of along the lines, well, does he have to pay to somebody? And yeah, I suppose, but yes, but at some point that obligation will end. If he's in breach, and you don't have somebody who comes forward and pursues the legal rights to remedy that breach within a proper period of time, statute of limitations would kick in, latches would kick in, and he would be home free, basically. And the one who can come forward to do this isn't Citibank. We've got however my colleague...
How long was the note?
The note?
Yeah, how long?
It was a
30
30 year,
years?
I believe.
And so did anybody ever accelerate the note?
No, I don't think so. Well,
So-
the deed of trust is an acceleration when you call for the sale of the property, sure. If it's a valid process, if it's not a valid process.
It's pretty, if you're saying it's an invalid process, then it didn't accelerate the note, so
Right.
then you've still got, I don't know, how many years left on the note to go, so it's still
Quite a few.
valid note.
And maybe whoever is the proper owner of the note deed of trust conglomeration will come forward at some time. But all we know right now is it's not Citibank. And that's the point of the lawsuit, that it's not Citibank. I think I've run out of inspiration. If there's no further questions.
Thank you very much, Mr.
Thank
Ed.
you.
The matter is deemed submitted. We'll issue a decision in due course.